If Your Honor has no more questions, the appellant would like to take Your Honor to submission 3. As to submission 3, the appellant respectfully submits that the occurrence of the ambulance being hit by the black sedan on the way to hospital is not novel actus intervenus in the eyes of common law. Firstly, according to the Australian Law Dictionary,
what do you mean in the eyes of common law?
The occurrence of the ambulance being hit by the black sedan does not fit into definitions of novus actus intervenus. This is the appellant's submissions, Your Honor.
And then you're referring to the Australian Law Dictionary as novus actus intervenus?
Firstly, in order to consider whether...
I'm familiar with the term. Could you move to your submission on March and Stromare, please?
Sure. Chief Justice Masons in March and Stromare held that, and may I dispense with citations? Yes. As a matter of both logic and common sense, it makes no sense to regard the negligence of the plaintiff or a third party as a suspending cause of novus actus intervenus. When the defendant's wrongful conduct has generated the very risk of injury resulting from the negligence of the plaintiff or a third party, and that the injury occurs in the ordinary course of things. In such a situations, the defendant's negligence satisfies the but-for test and is probably to be regarded as a cause of the consequence because there is no reason in common sense, logic, or policy for reducing to so regarded close quotes. And Your Honor, close supermarket should be held liable for the full injury of my client's legs. If my client had not fallen in close supermarket, she would have been transferred to a hospital by an ambulance. She would not have been transferred to a hospital by an ambulance. But for the fall, my client would not be hit by another car.
That is a pretty tenuous argument, don't you think? Are you suggesting it's reasonable to say, well, to all ambulances, whenever they get called out on duty, are they hit by another car?
The submissions from the appellant is that in order to draw authority from novus actus intervenus, the respondent need to overcome the but-for test. And in New South Wales, the but-for test has been used by court to decide the causations as well as the liability.
So are you suggesting that in New South Wales they isn't novus actus intervenus?
No, but in this case, because, using the but-for test, the car accident doesn't constitute novus actus intervenus in the eyes of law. The appellant is not arguing that there's another accident happened to my client, but what the appellant is submitting is that the accident is not substantial enough to breach the chain of causation in the definitions of the novus actus intervenus.
What would be sufficient?
I will refer Your Honor back to the quotation I just made about the Chief Justice Mason. If the actions, the new action actually totally changed the circumstances or situations, and that will consider as...
Okay, just to interrupt you there. So what injury had she sustained when she got into the ambulance?
It was from the fact scenario that wasn't clear because the plaintiff couldn't receive a proper medical diagnosis at that case. So I'm sorry, Your Honor, I can't specifically.
That's okay. What injuries did she have when she arrived at hospital, when she eventually got there?
She was diagnosed as serious ruptures of muscle, which was beyond repairable.
Okay, but nothing else?
From the fact scenario, there's no more information supplied. However, I believe that the respondent is very willing to supply medical.
Can I put this to you? If the plaintiff, your client, had arrived at hospital despite being hit by another car, happened with the ambulance. If she had arrived at hospital with the same injury, albeit a little bit
Sorry, Your Honor.
Okay, I'll start that because I'm thinking as I'm saying this. So say the plaintiff broke her leg in the store. She went into an ambulance, the ambulance was hit, however, she didn't actually get injured in that car accident. She just had the same injury that she had back at the store. When she got to the hospital, she just had the broken leg.
5 minutes.
Thank you. So, therefore, even though the ambulance was hit by a car, there was no novus actus inconvenience. Would that be correct? Because her injuries weren't worsened by the car accident. Would I be correct? Is that what you're saying?
That depends on what the appellant is submitting here is that the additional accidents, in this case being hit by a black sedan, is not substantial enough to constitute novus actus inconvenience in the definitions of in the definitions, in these legal definitions. Perhaps the injury was worsens, and however the chain of causation is not broken.
Okay, can I ask one more question?
Sure.
And I know you still have to get to your final submission. But the trial judge, Justice Lyman, found there were public policy considerations with regard to him finding a novus actus. Do you want to elaborate on those or refute those public policy considerations? Do you want to make any submission as to that?
Yes, Your Honor. The public policy referred by the trial judge basically is the public policy that excludes the party being found liable to an accident which is not responsible to. And in this case, if we apply the public policy which found by the trial judge, the appellant don't think that's just to actually extend the liability to the black sedan driver.
Thank you. Would you like to move on to your final submission, please?
Sure. As to submission 4, the appellant respectfully submit that Dr. Seaborn failed to discharge his duty of care by failing to warn Ms. Craig of significant risk. It has been a well-established common law doctrine that medical practitioners own a duty of care to their patients, and that includes warning patients of a material risk inherent in a proposed treatment. In Roger and Whitaker, the test to be applied in determining whether a particular risk is or is not material has been stated by majority of 5 High Court justices in the following terms. May I dispense with full citations? Open quote, a risk is material if in the circumstances of a particular case.
If you'd like, counsel, you can move on to your submission. You don't have to read out the quote.
Sure. The second point submitted by the appellant is that the decisions of whether to warn the risk does not depend on whether the expert, namely the doctor, consider is relevant, but the patients.
Okay.
The High Court in that case, Roger and Whitaker, found that even if a risk is not material, in the sense that a reasonable patient would be unlikely to attach significance to it, a medical practitioner may still be held to be negligent in the circumstances of a particular case, if the tribunal of fact is satisfied that the medical practitioner was aware or ought to have been aware that the particular patient would be likely to have attached significant risk to it. In other words, for example, when the patient claims to have an idiopathic fear of sustaining a particular disability, even if the doctor was not aware of these circumstances, it may be open to contend that by making prudent inquiries, the doctor ought to have discovered. In this particular case, Your Honor, my client was not able to move freely without aid. She had been walking with crutches by the time of surgery. She clearly expressed to Dr. Seaborn that she was very concerned about not being able to walk again. She relied on her upper body to walk with crutches. The conditions of albonesia is described as the elbow become inflamed and difficult to bend or weight bearing. During the 6 months' time of suffering from albonesia, my client was not able to walk at all, and she relied on her upper body using her arms to hold the crutches. That is exactly what she had worried about. She couldn't walk. Ms. Craig was deeply frustrated and extremely anxious.
Well, she wasn't worried about getting albonesia, she was worried about not walking.
That's correct, and albonesia is the sole cause which necessarily and sufficiently cause her disability of walking. Your Honor.
So her elbows are affecting her legs.
No, because because my client actually was walking on crutches, and because of the sickness, albonesia, she was not able to move at all because her joints were all swollen, and she couldn't use her arm to hold the crutches to walk around. And that was exactly as she had.
It seems like you've run out of time. Would you like an extension of time?
Yes, may it please the court, the appellant would like to apply for extensions for appellant submissions.
I'll give you 1 minute.
Thank you, Your Honor. Ms. Crick was deeply frustrated and extremely anxious, as no one was able to tell her how long the condition was going to last and when she could walk again. I hereby submit that Mr. Seaborn failed to discharge his duty of care by failing to warn Ms. Crick, the significant risk which caused Ms. Crick suffer harm. And therefore, the appellant, as submission 5, respectfully submit that the leave for appeal should be granted to the appellant. Thank you, Your Honor.
There is just one question, and I will give you extra time to answer these. Didn't the doctor warn your client that there's a small chance that other muscles in the legs could be damaged so that she might not be able to walk again? Therefore, according to your submissions, if your client was concerned about not being able to walk again, the doctor actually did warn her about that prior to taking on the operation.
The information provided by the doctor is that may damage the muscle, but the definition of damaging the muscle is unclear. In this case, there was the evidence is the symptoms of temporary swollen and pain and unable to lift weight. And damage of muscle can mean just, Your Honor, after some people actually have demanding exercise, sometimes they feel their muscles are aching, and that also can classify as damages in medical terms. And therefore, the advice provided by Dr. Seaborn to my client wasn't sufficient and clear enough to inform my client that a significant risk.
Thank you, Mr. Secretary.
Thank you, Your Honor.